It's early evening, and you're relaxing in your favorite chair, enjoying some quiet time and privacy. Your doorbell rings, then the knocking starts. You hope it's not some random person trying to sell something. If you wanted your gutters cleaned or AC inspected, you'd call a technician. A voice shouts out, "Police, welfare check." You hadn't called for help. Did a neighbor call? Your mind throttles to the one question that matters. Can cops use a welfare check as a pretext to enter your house? How do I stop it? This is more annoying than a peddler. Welcome to the Four Eyes of Law. I am attorney Larry J. Brookins, a California trial attorney with over 25 years of litigation experience in both the state and U.S. federal courts. 10 of those years were spent with two of the largest government agencies in Los Angeles. As a lawyer, we must give our mandatory disclaimer. This video is for informational purposes only. It is not intended to provide specific legal advice about a specific case or person, or to establish an attorney-client relationship. As always, our first line of advice, if you are facing a serious legal matter, is to consult with an attorney of your choice. See our full disclaimer in the description. That said, let's talk law. We start with the first key principle, which is that your home is your castle. It is protected by the Fourth Amendment to the United States Constitution. Also, Article 1, Section 13 of the California Constitution provides very similar protection on the state level. The general rule is that police need a valid warrant to enter a person's home. They do not get a free pass just because they labeled a visit a welfare check. In the case of Caniglia v. Strom, 2021, the United States Supreme Court held that the community caretaking exception alone does not justify entering a person's home. In California, in the case of People v. Oviedo, which was decided in 2019, the court rejected the idea that law enforcement can enter a home simply under the pretext it is for community caretaking. The court said an entry based on caretaking requires either a warrant or a real emergency. This has become known as the Emergency Aid Doctrine warrant exception. In the case of Brigham City v. Stewart, the court clarified the emergency exception. The court said that an emergency may exist when an officer has an objective need to act immediately to protect life or prevent serious injury. Beyond emergencies like that, California law also addresses situations involving mental health crises. Now, in California, there is also a mental health lane that may allow police to enter a home without a warrant. The California Welfare and Institutions Code, Section 5150, provides that if an officer has probable cause to believe a person is a danger to themselves or others, or is gravely disabled due to a mental health condition, they may detain that person for evaluation. Such situations may justify entry into a home when immediate action is required. Section 5150 also allows for mental health holds when there is probable cause of danger, grave disability, or other emergency factors. Some people who believe that law enforcement is falsely using a welfare check as a pretext to enter their home take the following steps to prevent it. But first, understand that there are often two common situations that present themselves when officers arrive for a welfare check. In the first, the officers are speaking directly to the person whose welfare is being checked. In the second, the person in question is somewhere else in the home and not part of the conversation. If the officers are speaking directly to the person whose welfare is being checked, that person can handle the communication themselves. They remain respectful, but speak to the officer only through a closed door or a window. Others turn on the porch light, make sure their security camera is recording if they have one, and ask the officer what the specific emergency is and who called it in. These homeowners are careful with their words and understand how easily language can be misinterpreted. Example, phrases like "come in for a second" or "take a quick look" are often treated as consent by law enforcement, even if the person did not mean to give permission. Such words may be interpreted by an officer as permission to check every room throughout the home. In the second scenario, when the person whose welfare is in question is not at the door, another household member may be the one speaking to law enforcement. In this case, the same respectful tone applies. That person can explain that the individual the officers are asking about is inside and safe, but does not wish to come to the door. They can also offer to have the person show themselves briefly at a window if it is safe and comfortable to do so. Before we continue, if you find value in this video, please pay it forward. Hit the subscribe and like buttons and tap the bell. This helps other people who need this information find this video. You'll also have it saved and won't have to search the web again when you want to review this information. Now let's look at what happens when other people inside the home are the subject of the welfare check. If the person speaking cannot safely confirm their status at the door, officers may step up their efforts to verify safety. The best way to stay in control is to bring the person to the door or a window, if that can be done safely, and let them speak for themselves. If they are asleep, say so. If they do not wish to speak, state that clearly as well. However, it is important to note that if there are specific facts that suggest immediate danger, an officer may move into the emergency lane. Emergency situations may allow entry without a warrant. In non-emergency situations, some homeowners understand that if the police say they just need to check a person's welfare, the welfare status can often, but not always, be satisfied without opening the door. Sometimes the person being checked on can simply say, "I am okay, and I do not consent to you entering my home." Others may choose to show their face through a window and hold up identification to the glass for the officers to see, and say they are fine and do not consent to cops coming inside. Some people have called the 911 dispatcher while the officers are still at the door or on the scene, informing both the dispatcher and the officers that they are safe and do not consent to entry. Others have even asked the officers to call for a supervisor. Remember, consent is a choice. People are allowed to say they do not consent. However, if law enforcement attempt to enter without a warrant, do not block the doorway, argue, or resist, and definitely do not become physical. Clearly repeat that you do not consent and that you are not interfering. Step out of the officer's way and keep your hands visible. Memorize names and badge numbers if possible, and contact legal counsel of your choice as soon as you can. Hopefully, the officers are wearing body cameras, or a home security camera is recording the incident. Remember, your entryway is not the place to fight your battle. The proper arena is the courtroom, with your attorney by your side. Before we conclude, if you found this video helpful, tap the subscribe button and ring the bell. It truly helps others who need this information find this video. Remember, law is knowledge, and knowledge is power. To conclude, the general rule in California is that entry into a home by the police requires a warrant. However, there are fact-based emergencies and limited exceptions that allow entry without one. If you found this video helpful, please hit subscribe and tap the bell so others can find it. Now, check out this next video. Thanks for watching.